Hi, my name's Stuart Solon, and today I'd like to talk to you about Arizona's assault statute. So if you've come across this video, then perhaps you or someone you know may have been charged with assault, and this video is designed to help you. So what I'm going to do is explain the statute, what it says about assault. We'll also talk about the penalties that you could be facing if you're convicted under one of the subsections of the statute. And I also want to go over with you some common defenses that I see in assault cases, which might be of benefit to you. So first, let's define what assault is in Arizona. The Arizona assault statute is called ARS 13-1203. Just so you know, ARS, that stands for Arizona Revised Statute, and 13-1203 is the specific statute in the criminal code that talks about assault. Under that statute, there's actually 3 different types of assault that you can be charged with. And these different types of assault are in what are called subsections of the statute. Now, you can see which subsection that you specifically were charged with, usually because on the citation, on the piece of paper that you get from the police when you're arrested, there'll be a statute and it'll say ARS 13-1203, but then to the right of that on the same line, then there'll be in parentheses a subsection number. So this will say either A1, A2, or A3. And those are the different subsections for misdemeanor assault. So let's break it down so that you can understand that statute, and we'll look at each subsection individually, starting with subsection A. So this would appear, for example, on a citation as ARS 13-1203A1. Now, under this subsection, and I'm just reading from the statute here, a person commits assault if they intentionally, knowingly, or recklessly cause any physical injury to another person. This is a Class 1 misdemeanor, and that is the most serious type of misdemeanor that exists in Arizona law. It's also the most serious type of misdemeanor assault charge that exists under Arizona law. In fact, for you to be charged with a more serious type of assault, you would have to be charged with aggravated assault, and that's a felony. So, whatever happens, at least you're not charged with aggravated assault, okay? So A1, though, it is still the most serious type of misdemeanor assault, and that's because it requires an actual physical injury to the victim. So this doesn't have to be a major injury. Anything minor will count. A bruise, a scratch, something like that. That is, that's physical injury. If you hit somebody, even if it doesn't leave a bruise, but the victim testifies that it hurt them, well, that's a physical injury. So this type of assault, it's what you would commonly think of when you think of the crime of assault. A common example like this, the classic example would be, punching somebody, right? That's assault, and it's A1 assault. So you see that the language of the statute, assault, says that it can be committed either intentionally, knowingly, or recklessly. These are what are called criminal states of mind. If you do something intentionally or knowingly, let's take, for example, the example of hitting somebody. It's when you act in such a way where you're going to hit the other person. You think in your mind, I want to hit this person, and then you hit them. That's acting intentionally. Knowingly is pretty much the same, but slightly different. It's where you say, okay, I don't intend to hit the person, but I know that by moving my fist in this direction right next to this guy's face, I'm going to hit the person. That's knowingly committing an assault. So this is different from if the crime occurs recklessly. recklessly, what that means is it's essentially a type of extreme carelessness where you're acting in such a way that you don't actually intend to punch anybody. You don't necessarily know that you're going to punch somebody, but you're acting in such a way that you're aware of this risk and you disregard it. So if you're flailing your arms around in a crowded room, you know that it's a good chance you could hit somebody by doing that, and that is acting recklessly. And so you can commit an assault in that way as well. Now, we've already talked about how A1 assault is a Class 1 misdemeanor. So I want to talk a little bit more about what that means when it comes to potential penalties. So a Class 1 misdemeanor, like we said, it's the most serious type of misdemeanor, which means you can be facing up to 6 months in jail plus $2,500 in fines. You will also be facing surcharges for those fines, which can effectively double that amount. So in addition to that, you can also be placed in classes like anger management classes. That's a common type of class that they can place you in as a term of probation for the assault conviction. And speaking of probation, you can be placed on probation for a term of up to 3 years. And this misdemeanor probation isn't particularly harsh compared to something more serious like felony probation, but there can be terms which can still be burdensome. Common term of probation, especially ones that involve convictions for violent crimes, is that gun rights can be taken away during the term of probation. Your term of probation might say that you're not to possess any firearms while you're in probation. Now, the second type of assault, I'm going to move to the second type of assault now. This is subsection A2. And under this, I'm going to read from the statute again here. What the law says is that a person commits assault if they intentionally place another person in reasonable apprehension of imminent physical injury. Okay, let's break that down. A lot of unusual legal jargon there. First of all, we have reasonable apprehension and imminent physical injury. These are terms we don't commonly use in real life, but they do have specific legal definitions. And so let's start here. So basically what this means is that a physical injury does not actually have to occur for an A2 assault to occur. You just have to commit actions which would place another person where in their mental state they're thinking that a physical injury is going to occur. So what this does is it doesn't punish the actual assault, the actual physical injury, what we would commonly call assault. It's more punishing the fear you instill in another person that an assault is going to happen. So let's take an example of this. Okay, somebody winds up to take a punch and they're really close to the other person so that it makes the other person flinch, thinking that it's just this instinctive reaction to protect themselves from the oncoming danger. Now, that is an example of placing somebody in reasonable apprehension, and that is what is punished under the A2 section of assault. Now, because no actual injury has taken place, it is designated as a lesser type of crime than A1 assault, so it is a Class 2 misdemeanor. Now, a Class 2 misdemeanor, that's one step below a Class 1 misdemeanor, but it can still result in serious punishment. The maximum penalty for a Class 2 misdemeanor that can be imposed is 4 months of jail, as well as $750 in fines. And like with the fines in A1 assault, these can essentially be doubled with the surcharges once all of those are included. The probationary period that you could be looking at is for a term of up to 2 years. And again, the court can impose things like anger management classes and community service as a consequence, as a term of probation. Now, the third type of assault in the assault statute is subsection A3. A person commits this type of assault, and again, this what the statutory language says is if they knowingly touch another person with the intent to injure, insult, or provoke them. This is a less serious type of assault under the statute, but it's still a crime, and it's classified as a Class 3 misdemeanor. And in this type of assault, any type of touching that is unwelcome and meant to anger the other person can qualify. You can see a lot of different types of crimes that fall under this when there's no physical injury. And I've seen it in a lot of cases, usually where somebody's arguing with another person. Maybe they get in their face. Let's say another guy pushes the other guy. Okay, but there's no real physical injury that occurs from that push. But it could still be classified as an A3 assault, a Class 3 misdemeanor, because you're not pushing them, for fun, right? You're pushing them to insult them or to provoke them. Another common way that you can see this is in situations where maybe you're at a club and you get into it with a bouncer. Maybe you don't cause physical injury to the bouncer, but if you try to touch the bouncer or provoke him when you're at the club, then I can see a lot of cases that are charged against the patron of a club, against a bouncer, where there's no real physical injury, but there was touching involved and provocation, and so the police will charge that as an A3 assault. Now, like I said, this is a lesser type of assault, but it's still a criminal matter. It can still result in up to 30 days of jail, $500 in fines, plus essentially the double that comes with the surcharge, 1 year of probation, anger management classes, community service, things like that. Okay, so those are the three basic types of assault in Arizona. Now, if you're charged with one of these, you're probably thinking, what can I do about this? Well, the good news is that there are usually two sides to every story, right? And that's what the criminal defense attorney that you hire is there to prove. Now, the prosecutor, when they're making a charging decision in the case, they're going to be presented essentially with the police report, and that's often just going to be a one-sided story, which will have the victim side of the story, and it won't include a lot of evidence that helps your case usually. So that's the job of a defense attorney, is to find as much evidence as possible to help your case and present it to the prosecutor to see if we can negotiate a deal where we can reduce or perhaps get the charges dismissed entirely. And if that doesn't work, we can always use that evidence to then fight the case in court and try to convince a judge or a jury that you're not actually guilty of assault. So how do we do that? Well, there are some common defenses to assault, some of which you may have heard of probably. There's the concept of self-defense, and that's where if you're defending yourself during an assault, you can take physical action against another person, and that physical action could be justified as self-defense. The same thing's true if you're taking physical action in order to protect somebody else, in order to defend them. Then that can be called the self-defense, the defense of others. It's also a justification for assault. Or maybe the evidence shows that the victim's just making up what they're saying, and there's just not enough evidence to show that an assault even occurred. Maybe the police were taking the victim's word for the assault without any corroborating evidence, and there's good reason why the victim shouldn't be believed. A victim can have biases, and there could be reasons for them saying what they're saying that's not truthful. Or perhaps the victim has a criminal history, and that's something that we can look into, and it can be brought up in a court of law to show that they're not a reliable witness if they're been convicted of certain felonies or been convicted of other crimes that show moral turpitude. In other words, crimes that show that they're not trustworthy people. So their testimony can then be discounted. Now, keep in mind also that the prosecutor has to prove their case beyond a reasonable doubt. That means that they can't just have some evidence that an assault occurred. They have to have enough evidence to cast aside any reasonable doubt of your innocence. So it's a high burden that the prosecutor has to meet, and the prosecutor usually knows that. Sometimes the prosecutor might have enough evidence to charge a crime, or the police might have enough evidence to write a criminal citation, but just because that happens doesn't mean that they have enough evidence to actually prove their case in court. Now, clearly, every case is different, and depending on the specific facts of your case, the defenses might vary. They might include different defenses than the one that I've mentioned today. But if you've gotten this far in the video, then you probably want to know the types of defenses that can apply to your case specifically. And if that's the case, then I highly recommend that you speak with a criminal defense attorney, whether it's me or some other criminal defense attorney that you trust in Arizona. Most of them will offer free consultations. I certainly will offer free consultations on criminal defense cases. So pick up the phone, get their take on the case, and the point is you don't want to go this alone. Things that you say can be used against you. Remember that. And you might think you're doing yourself good by disclosing certain evidence to the police or to the prosecutor, but you could actually be doing more harm than good. So I highly recommend that you speak to an attorney. You do have the right to counsel in criminal cases. Use it. I've had a lot of experience in dealing with misdemeanor cases all throughout Arizona, both in the justice courts as well in the city courts, and those are the courts that usually prosecute misdemeanor assault cases. I've been able to have assault cases dismissed outright. Sometimes I've been able to have cases dismissed where the defendant enters into a diversion program where they take some classes and then the case gets dismissed. But if you have any questions after watching this video, please give me a call. I'll be happy to help and see what I can do to help you.